Thanks for coming tonight. My name is Dane Claussen. I'm the Executive Director of the James Pedas Center. We're having a variety of events this year in the Pedas Center. One event each month that is on general communication skills or knowledge, and one each month that's specifically oriented toward media literacy. So tonight is our communication skills night for November, and tonight I'm speaking about copyright law and the fair use exception, which is important to all of us. So what is copyright law? Well, it's control over your creations the second they are put into tangible form, which now includes digitized forms such as websites, digitized photos, and so on. I also like to think about it as one big exception to the First Amendment. And why do I call it one big exception to the First Amendment? Well, because it is a limitation on our use of other people's words, other people's photographs, other people's ideas, not so much ideas, but how they manifest themselves, and so on, right? So copyright law actually predates the First Amendment, so it's not like something was carved out of the First Amendment later, but copyright law actually goes back 500 years. And this tells you something about why it was a matter of control and a limitation on free speech, not just a protection on it. And that is that it was set up by the King of England to basically perpetuate monopolies over printing. And it was very much a command and control motive there. Anyway, if you think about the idea of copyright, if it were strictly enforced, without any kind of exceptions or any kinds of just day-to-day, give and take on it, where we don't enforce it on all each other all the time. Think about, for example, when you hear a joke and then you tell someone else the joke. Well, someone made up that joke. You may even know who made up that joke. What if every time you told a joke that you had from somebody else, you had to get permission from the person that you heard it from? Or you had to track down who actually came up with the joke and give them credit each time you told it. That is essentially what copyright law would suggest if it were really, really tough and hardcore all the time about everything. But it is not quite like that, and in fact we have a major exception to copyright law in the United States called fair use, and I will get to that in a few minutes. But before I do that, let me just say a few things about what I might call my encounters with copyright law over the years. First of all, I've been around university campuses as a student or as a professor for most of my life. And one of the instances that you will see on campus of a copyright problem or potential copyright problem is when student newspapers or student yearbooks will run a photograph in the newspaper yearbook that they obtained off a website or out of a book or off of a poster on campus or something else like this. And they don't give credit at all, or in some cases in student newspapers are famous for saying, photo courtesy of 20th Century Fox Films, or photo courtesy of Adidas company, right? And this is actually, there's some gray area here, but there's also some thick, bright lines. When a photograph is published in a student newspaper and it came from, say, a recording company, and you know that the recording company's got public relations staff and they send out press releases with photographs attached, and they also post them on websites, and they want those photographs to be used. And they don't really care where those photographs are used or when they're used or how they're used exactly, as long as as long as you don't manipulate them in any way. They would prefer that you leave their photos alone if you're going to use them. But students oftentimes just sort of act like whatever is out there is fine. But the fact is that there's photographs in books and on websites and so on that are not there for public relations purposes, that actually people want to control the use of. And that students need to be much more careful about. So when a student newspaper says courtesy of Harper and Row or something, it suggests to me that that they needed permission and they got it, but that's usually not the case. Within the past couple days, on the College Media Advisors listserv, I'm a member of that organization, a student newspaper advisor at Cabrini College, which isn't terribly far from here, posted this note: has anyone received a letter from Higbee and Associates demanding payment of $1,500 because of supposed copyright infraction? Our editor, this is a student newspaper at a small college like Teal, our letter received a very official letter demanding removal of a photo and payment of $1,500 or further action would be taken. They said they represented a photographer named Scott Serio. The photo, and then he comments, the photo we used, however, was from Tribune News Service, formerly MCT Campus, and was completely legal. I can't tell if this is a mistake on the photographer's part and his lawyer, or if this is some aggressive and careless pursuing of college newspapers. If here the lawyer checked closely, they would have found the photo credit in the online caption. Well, at least that student newspaper perhaps has covered themselves and is going to tell this firm to go away, but in many of these instances, the student newspaper is much more at risk. How about when I was in college, which was now well over 30 years ago, a big thing for professors to do would be to put together a course packet. And there were hundreds of these on a large university campus, and some of these course packets consisted of nothing but scholarly journal articles and book chapters, and sometimes these packets would be 500 or 600 or 800 pages. The primary purveyor of these photocopied packets was a company called Kinko's, which now is FedEx Office. And Kinko's started way back in the late 1960s, and by the late 1970s they were photocopying with abandon, and students were paying for these packets for college. Well, Kinko's got sued. You may have heard that at some point. And they lost badly. Kinko's was photocopying as much as 25% of a book for a course packet, as well as thousands and thousands of scholarly journal articles. And Kinko's, if you go to FedEx Office now, they've basically got signs all over the place that says, we won't copy a book or a journal for you, or a magazine or newspaper, and you do so yourself at your own risk. But I remember both when I was still in high school and when I was in college, seeing these packets and wondering whether this was all kosher, and of course it was not. Much later in my career, just thought of various instances I wanted to talk about that illustrate various things. I wrote a chapter for a scholarly book, and I submitted it to the co-editors, and the publisher would not publish it unless I could prove to them that I had permission to use pretty much all of the direct quotes in my book chapter that came from newspaper articles or magazine articles over the years. And it's a reasonable question, except for the fact that almost all of the quotes that I used in the chapter were very short, sometimes only a sentence long, sometimes just a part of a sentence. I used quotes from a variety of different issues, also a variety of different magazines and newspapers, and it was all fair use. So when I asked the publisher, could I talk with your lawyer about your policy on this, because you're being unreasonable. I don't need permission on all these tiny quotes scattered throughout my chapter. I was told, we don't have a lawyer. And I said, well, where did you get your copyright policy from if you don't have a lawyer? Could you imagine this, a book publishing company without a lawyer? And they said, well, we got it out of a book. And I said, well, which book? And they told me, and I looked it up, never heard of the book, and it was written by an English professor. And they were apparently, this was the one and only book they were using for their copyright guide. Now, I don't have anything against English professors. I love English professors, but I wouldn't take legal advice from one. and I especially wouldn't take legal advice from one if I were running a book publishing company. And their advice, their policy was flat out wrong, and I ended up not publishing that chapter in that book because I wasn't going to give, and neither were they. Another book publisher that I worked with was a book that I published myself, requested I get permission to use essentially every quote that I had in there from issues of Life magazine and Time magazine from the 1950s and the 1960s. And this was in about the year 2000. So I will return to that later about why that was silly. You'll realize it yourself, I think. So one of the things we have to know is that there's a lot of people out there, including maybe many of us in this room, who are flying blind on copyright or just using sort of guesswork. And in worst case scenarios, like this book publisher didn't publish my chapter, essentially bluffing, sort of acting like they had a knowledgeable copyright policy, and they were just citing some book by an English professor and not really understanding the law and not making any attempt to. That was at least my opinion of the matter. Anyway, so at about the same time I was publishing a couple of other books, and I was reading carefully the contracts that I was being asked to sign. And what started happening in the late 1990s was that book publishers would start formulating their contracts so that the publisher got all of the benefits of the book contract and the author got all the costs and all the liabilities. Now, think about this for a second. So basically these contracts that I was asked to sign, which I did because I wasn't concerned, but I was still annoyed, said, we get all the profits from the book, we keep the reprint rights, we keep the translation rights, we keep the film rights, we keep the right to edit your book as we see fit, to essentially do whatever they want to do with it. But if we get sued because of something in your book, like libel or invasion of privacy, or obscenity, or something else, then it is your problem. You have to hire the lawyer to defend yourself and us from a copyright infringement lawsuit, an invasion of privacy lawsuit, or whatever. So basically, the publishers are taking all of the rewards, all of the benefits, all of the profits, and sticking their authors with all of the costs and all of the potential liabilities. So this is the way copyright law is being deployed today by book publishers. Not too long after that, I was teaching at Point Park University in Pittsburgh, and over the summer in 2003, I think it was, we received from the administration, basically, that's the faculty did, essentially a notice saying that by decision of the Board of Trustees and on advice of the lawyers of the university, that the university was advised under the Digital Millennium Copyright Act, which I'll also mention more about in a little bit, that the university was asserting ownership over everything the faculty did at the university. In other words, all of our journal articles, all of our books, all of our conference papers, all of our syllabi, all of our exam questions, all of our assignments, all of our lecture notes. The university was simply asserting that they owned all of that. And supposedly this lawyer told them that this was required by the Digital Millennium Copyright Act. Now, let me just say for the moment that the Digital Millennium Copyright Act requires no such thing. It does not require a university or a corporation to unilaterally and completely claim ownership of everything their employees do. Now, I will say that it is true that there is a case to be made that university professors, like everyone else, maybe the university college does own everything we do. We are, under a work for hire doctrine, we get paid to produce lecture notes and exam questions, and so why doesn't the college or university own them? And in fact, there's a good legal case that maybe they do. but it was not required by the Digital Millennium Copyright Act. And in fact, any university would be stupid to say we own all of your lecture notes and all of your exam questions and all the books and articles and papers you've ever written. That'd be for several reasons. One, no professor would work for that university. You would have professors working there at that moment that would quit, literally resign. And certainly professors could argue that it's a breach of academic freedom and even a restraint of trade. In other words, what do professors do? If you work at one university and it takes away all of your notes, all of your exam questions, all of your assignments, all of your articles and books, well, how can you actually get a job anywhere else? So, overall, what's been happening over the years, as you might sort of gather from these anecdotes, is that corporate America, book publishers and everyone else, have been getting tougher and tougher about copyright infringement, by violating their copyrights. And they have been repeatedly going back to Congress and getting copyright laws toughened up. And I'll talk about that in a little bit too. And they've been getting a receptive audience at the United States Congress and in some of the courts as well. So what are the arguments they make for having tough copyright laws in the United States? Well, one argument is that intellectual property producers in the United States, which means everyone from comic book publishers to software manufacturers to film producers to newspaper publishers, are losing billions and billions of dollars every year to copyright infringement. The typical scenario they will paint is that, say in China, there's a 1.35 billion people there, and some large percentage of them are systematically stealing, without paying for it, American movies, American music, American books, and so on and so forth. And the trade associations for publishers and movie producers and music industry companies all have statistics about how much money they think they're losing to this piracy. It is true they're losing some money to the piracy. Of course, I'm not unsympathetic to that, but not nearly what they claim. They're typically making a worst case estimate, which is that if some very, very poor person in Ghana or somewhere weren't stealing a movie, that person otherwise would be paying $60 or $80 for a DVD. And it's just silly. I mean, if that person can't steal the movie, pirate the movie, that person wouldn't be seeing the movie at all, because they're not going to pay $80 for DVD in a village in Ghana or most of the other places in the world. But those are the statistics that are bandied about to Congress. Secondly, there is an organized lobby for the movie industry, the software industry, the recording industry, and every other intellectual property industry, and they lobby Congress regularly on piracy and copyright problems and so on. Meanwhile, who benefits from the exceptions to copyright law, the fair use and other exceptions? Well, professors, teachers, students, journalists, artists, inventors, poets, archivists, museum curators, librarians. And where is our lobby? Well, we don't really have one. Not for protecting like the fair use exemption to copyright law. It's not to say professors don't have lobbyists. It's just that we generally have higher priorities in Washington than complaining about the fair use problems with copyright. And finally, the intellectual property companies, the movie studios and so on, they make this argument that, they literally make the argument that if there were not strong copyright law protection in the United States, that no one would ever create or produce anything in this country. Right? That a strong copyright law is absolutely necessary because otherwise all creative activity in the United States would grind to a halt. Now, is this true? Well, maybe, maybe Justin Bieber would stop making new songs if he didn't have copyright protection. But this is demonstrably false. Everywhere in the United States, there are people writing poetry who don't worry about copyright, people writing songs who don't worry about copyright, people painting pictures and people writing novels and so on who don't worry about copyright. People, writing plays who don't worry about copyright. I mean, they literally would do it without copyright protection. And people are doing these things every day all over the United States, not thinking for a second about, I'm so glad there's copyright law because otherwise I just would stop writing poetry today, or at least by tomorrow. Now, the fact is, maybe 20th Century Fox would stop making movies if they didn't have copyright protection, but most people in the United States are not 20th Century Fox, or Harper & Row publishers, or Apple making software or whatever, right? So there has been a backlash to copyright law becoming more and more draconian, I'd say. I don't think that's an unfair phrase, or an unfair sentence. We have something called the Creative Commons in the United States, where you could actually produce a book or a movie or anything else and register it with a Creative Commons organization. And this is a declaration, I am not claiming copyright to my own work. And anybody can do with whatever they want to with what I produced and registered with Creative Commons. This is a major movement in opposition to tough copyright laws. There's a word that got coined that is the copy left. In other words, people who are, liberals or dissenters or protesters over current copyright law in the United States, the copy left. Well, just to give you a little bit of historical background before we get into specifics about fair use, which is really what I want to talk about tonight. The Continental Congress, this is going way back, the Continental Congress did not have authority to pass a copyright law, but the U.S. Congress, set up by the Constitution, certainly did, and they did. The first Copyright Act was in 1790, and the U.S. Constitution actually establishes copyright. It says, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, Congress thought copyright law was pretty important, even though it had been something that had been used in a lot of bad ways by kings and queens of England, that it was important to protect science and art and literature and so on. So it's right there in the body of the Constitution. It predates the First Amendment. The first Copyright Act provided for 14 years of protection over maps, charts, and books, and it could be renewed for 14 more years if the author were still alive. So the maximum anything could be copyrighted for was 28 years. It did not prohibit, by the way, Americans from copying foreign books, pamphlets, plays, and so on. And if you know anything about the history of the American printing and publishing industry, Americans were copying, especially British newspapers, magazines, and books, just voraciously for decades. A lot of what appeared in American magazines and newspapers, even up through the Civil War, was stuff that was borrowed from British books, newspapers, and magazines. So, of course, were Americans who were writing too, but that good British stuff was too hard to pass up. So, what did early Americans think about copyright? Well, between 1790 and 1799, 13,000 books were published in the United States. 13,000 different titles, and only 556 of them were copyrighted. So there were a lot of people who were willing to publish a book and not bother without getting it copyrighted. They knew about copyright, they just didn't do it. They didn't care. So in 1831, the term was changed to 28 years with a 14-year renewal. And then in 1909, it was changed to a 28-year period with a 28-year renewal. So even as late as 1909, the longest anything could be copyrighted was 56 years. And if you own the copyright, you actually literally had to go through a process of renewing the copyright at the end of the first 28-year period to have it for the second 28-year period. The next thing that happened was much more recent. In 1976, there was a major Copyright Act passed, and the copyright law was extended to unpublished work, and the copyright term was extended to either 75 years or the life of the author plus 50 years. So it was only an extension from 56 years to 75, or the life of the author plus 50. It wasn't that big of a change. It put the fair use exemption into law, which previously had been only a matter of court decisions and some state laws. It said, like, okay, at the federal level, we're going to have a fair use exception for copyright law. But it also made it easier for someone to get prosecuted as a criminal for infringing on other people's copyrights. So you see the beginning of the criminalization of copyright infringement right there in 1976. In 1985, the Supreme Court ruled, well, wait a second, copyright infringement really shouldn't be theft, not the way like robbing a bank or stealing a car is, but Congress sort of kept at it and has said, no, yes, it is a criminal act, and they've made the penalties tougher and tougher. Anyway, in 1992, the need to renew a copyright was eliminated. And in 1998, with the so-called Sonny Bono Copyright Term Extension Act, the renewal period, the copyright period was increased to life plus 70 years of the author. If the copyright was owned by a corporation, it would be either 95 years after first publication or 120 years after creation. So what does this mean now? Well, anything that was created from 1923 onwards that was still protected by copyright in 1998 is still under copyright until 2019. So right now, this is 2015, and essentially nothing is going into the public domain right now. Public domain is when a copyright expires and anybody can do whatever they want with it, right? Right at the moment when they're in a period where there is nothing entering the public domain, unless people are literally affirmatively declaring that they're giving up their copyright to something, which is possible through Creative Commons, among other ways. So what happened in 1998? Well, it's also known as the Mickey Mouse Protection Act. And that gives you an interesting theory about who was behind this. The Walt Disney Corporation was behind a lot of this. Their congressman that they worked with was the singer Sonny Bono's widow. And Jack Valenti was then executive director of the Motion Picture Association of America. And they basically wanted to make sure that Donald Duck and Mickey Mouse, I'm not making this up, never fall into the public domain. In other words, there are people in Washington and Hollywood who think that basically Donald Duck and Mickey Mouse and other Disney characters should be under copyright forever. Literally forever. Which of course is not quite the idea we've traditionally had about copyright law. But they're scared to death about Mickey and Donald being used by weird artists or whoever, right? So I own copyrights to a couple of my books. What do I think about this? Well, what do you think I think about this? Life plus 70 years of the author, right? So let's say theoretically that I live till say the year 2050, which is I think is quite possible. So my copyrights will still be in effect until the year 2120. Do I care? No. I will be long dead. But more to the point, I can't. The books that I've written and edited are out of print. The royalty checks are tiny, and these are not any assets that I would leave to my heirs that would be worth anything. So again, and this is true for well over 90% of the books published in the United States, and well over 90% of everything done in the United States, whether it's software, video games, movies, songs, or anything else, right? So who's this Sonny Bono Extension Act really for? It's really for big corporations that own a lot of copyrights to books and movies and songs and software and so on, and not really about people like me. Although you might argue I benefit in some tiny, minuscule, almost undetectable kinds of ways. But anyway. So then the Digital Millennium Copyright Act of 1998 came along and toughened up the criminal penalties for copyright infringement, along with saying, well, basically everything that's digitalized is now covered under copyright law, both in the U.S. and around the world. The last thing that happened in the history was, the last major thing was in 2002, the Technology Education and Copyright Harmonization Act was passed by Congress. It's known for short as the TEACH Act. And the TEACH Act puts rules on colleges like Thiel about what kind of materials we can have in distance education, what kind of materials we can post on Blackboard or Moodle that are copyrighted. And there's, you may say like, wow, great, we've got guidance on using a lot of materials on the internet and on in-house systems, and yet the TEACH Act puts as many responsibilities and limitations on a college like Thiel as it does give us guidance and help. Anyway, so what is fair use? I've been mentioned it a bunch of times already. Fair use is when you don't have permission in advance to copy something, but you want to use it somehow anyway. And you can have a fair use of something even when you've asked for permission and been turned down. So fair use has to do with following the law and not with the whims of the copyright holder, which is a good thing. The downside well, let me just say also, fair use is generally to protect teachers, researchers, journalists who are engaged in criticism or comment or coverage. It also protects comedy, essentially. Parody, in particular, gets a lot of protection under the fair use, which is why somebody like Weird Al Yankovic can use other singers' music and even a lot of their words to make fun of them. There's a 4-part test for fair use about whether, let's say you want to photocopy part of a book to give to your friends or your students, whoever they might be, your neighbors. There's a 4-part test. First of all, what is the purpose and character of the planned use? And is it commercial or not? And why are you doing it otherwise? Secondly, what is the nature of the copyrighted work? I'll get to that in a minute. Third, what is the amount, portion of what you're planning on using? And third, what is the effect of your planned use on the market for the originally copyrighted work? Well, when you've got a 4-part test, anybody who knows anything about law knows that, well, to have a 4-part test in law, you've either got to pass all 4 parts, you've just got to pass 1 part. In this case, you've only got to pass 1 part. If you can make an argument that it's a fair use under any one of these 4 criteria, you're in the clear. You're in good shape. And publishers pretty much have to prove that, or say, if we're talking about publishers, that there's no possibility of fair use under any of the 4 criteria. In legal terms, we call this a balancing test, where courts look at the preponderance, like, what's the evidence that we should support the copyright owner here? and how much evidence or is there, how much logic and so on, history is there in terms of siding with the person who is getting sued for copyright infringement. It's a balancing test. It's highly fact sensitive. In other words, how many copies were made, how many pages were there, which pages were there, and so on, right? How many book copies of this book normally get sold? Did sales go down? I mean, these kinds of cases get into a lot of detail. And that's actually to the benefit of people who are getting sued for copyright infringement, because it's very difficult for, say, a book publisher to prove that their sales went down because the copyright got infringed. How can you prove something that didn't happen? It's proving a negative, right? Like that you say, oh, I lost out on so many sales. Well, what's your evidence for that? Are people, writing to your publisher company and say, I would have bought your book except someone infringed the copyright on it? I don't think so. So, so let's look at the purpose and character of the use. Like you want to photocopy, say, a book. Doing this for educational purposes is a huge trump card. Education is a non-commercial use. It is a highly valued use. And it's particularly protected by fair use if the photocopying you're doing or the other distribution by electronically or whatever is directly related to the course you're teaching or the lecture you're giving. I mean, it is right there in the middle of everything. It's helpful, for example, if you're doing this kind of thing online, that it's password protected. Only the students in the class are getting to see it. It was the instructor's choice, and so on, so that it is professor driven. In 1976, Congress also said they would allow spontaneous uses of copyrighted material. So, for example, and I've been doing this for years, if I see an article in a magazine that I'm reading with breakfast in the morning, and I say, aha, this would be great in my class today, I can run to the photocopier when I get to Teal, make photocopies of that article, and pass it out in class, only, say, a couple hours after I read it. This is a spontaneous use of a copyrighted article. I don't have time to get permission to use it in my class for educational purposes, but nor am I required to do that. It's actually a long-standing exception. Congress also said, well, a professor shouldn't do this all the time, shouldn't do this more than 9 times per semester, and I confess I've violated that a few times in my career. But also said that the number of copies, I mean the things that are copied should not all come from one magazine or one newspaper, all be written by one writer, and I've certainly respected that quite well because I bring materials in from a wide variety of sources into my classes. So another thing that's highly protected is a transformational use. Transformational use, maybe you clip part of an article out and then you attach to it your own comments about it. Well, that's a transformational use. You're taking the part of the article out of its original setting, out of its original purpose, and you're doing some comment and criticism of it for an educational purpose. That's transformational use. When artists, for example, use part of a painting and they change the colors and so on, that's also generally a transformational use of a copyrighted work. So, the second part of the 4-part test is the nature of the copyrighted work. What kind of advice can you give? Well, don't photocopy what are called consumables. In other words, workbooks. Say workbooks for school. They are intended, they're sold on the model that they're going to be used once and then discarded. And if, for example, a teacher makes lots of photocopies of workbook and then passes them out, that's definitely robbing the publisher of a lot of sales. What else about the nature of copyrighted work? Well, it's easier to get away with fair use for nonfiction than it is for fiction. For example, if I want to use a page of a book about the history of journalism in a journalism class, that's safer than using a whole chapter out of a novel. Because facts have a closer nexus to education, and facts themselves can't be copyrighted, even though how facts are presented can be copyrighted. But in terms of, say, a novel or a poem, it's all creative work, it's all copyrightable, and it's not factual material. So, another part of the nature of copyrighted work is it still for sale? Now, this used to be really easy. You used to just check whether a book was still in print or whether a movie was still available in DVD format or something, and you could very easily make a determination. If you were copying something out of an old magazine or newspaper, you simply assumed that it was no longer readily available for sale. I mean, can you go to the Greenville Record Argus and say, oh, I'd like a copy of your paper from July 12th, 1985? And they can just go to a back room and sell it to you? I highly doubt it. So, but now, guess what? This is all possible. The New York Times has been completely digitized. Every single article ever published in the New York Times since it was founded in 1851 is now available digitally. And journal publishers, book publishers, magazine, news publishers, and newspaper publishers are going back and digitizing, scanning all their past content and largely making it available for sale in a way that was not possible and not done before. So ironically, things have changed, right? Usually in the old days, books were available for sale the longest, sometimes for years in a bookstore. And newspapers, yesterday's newspaper was hard to get, last week's magazine was hard to get, and the DVD of a movie that came out 5 years ago was hard to get, and so on. But now it's all sort of changed. With everything being digitized, old movies are available, old songs are available, old newspaper magazine articles are available, and ironically, books are actually the thing that's maybe most likely to no longer be for sale. Books go out of print these days very fast, typically in 8 months to a year and a half. So you're maybe safer than you used to be on copying a book, because it's probably more likely than it used to be that it's no longer for sale. So the third part is what amount and substantiality, as they say, of the book did you use? Well, back in 1976, Congress basically said, well, don't copy anything more than 1,000 words without permission. Can you imagine that? 1,000 words? It's a couple pages of a book. You couldn't probably under 1,000 word limit, you couldn't copy more than a couple pages of a book without getting permission. But this has been largely ignored over the years. It probably a safer rule now is you could probably get away with photocopying 5 or 10% of a book, which may be a lot more than just 2 pages. But it starts getting into sort of a balancing test again, right? At what point does photocopying a book start cutting into potential sales of that book? And it matters what part of the book. Because, for example, if there's a bombshell on page 137 of the book, like, about, something between President Reagan and his wife or something, and people are buying the book just for that, to read that one page, and that's the one page that you photocopy, you can actually probably get nailed for an unfair use, because you picked the part of the book to copy that's actually driving the sales of the entire book. Strange as it may seem. So then we get to the last part, which is the effect of the use on the market. And this, of course, was the real crux for the average publisher or movie producer or whatever. They mainly wanted to base their claim for damages on how much money they were losing based on having their copyright infringed. This was all about money, folks. And as I said earlier, the benefit, if you decide to be if you decide to be a serial copyright infringer, is that, and I hope you aren't, that proving that you lost X number of sales of books or software or movies or recordings and so on is quite difficult for these corporations to do. They'll roll out their numbers on average number of movies sold and this and that and the other thing, and the recording companies in particular will argue that their sales have gone down so much over the past 20 years because of copyright infringement. I might cynically suggest, no, maybe American music is just getting worse and worse. And people don't want to buy it anymore at all. So there's lots of cases over the years of been pro and con for fair use that are all very unique, and every case has to be looked at on its own merits. But I will say one of the points that is important here is that judges in the United States have started realizing that Congress is going to just keep on sort of doing the bidding of major corporations who want to toughen copyright law in the United States and limit fair use. And judges have basically started saying, well, especially in the last 5 or 10 years, like, wait a second here, Congress is not really respecting the philosophy or the history of copyright law, and basically is just sort of taking orders from Microsoft and Disney and so on. So judges are actually starting to focus mainly on two things. One was more and more on this issue of transformation. Is there transformational use? Broadening their definition of transformational use. This gives people more and more latitude under fair use. And secondly, what is the community of practices, customs, and habits? In other words, perhaps looking at university professors, and if, for example, I got sued for copyright infringement and it went to court, a judge might wonder, for example, am I basically like most other professors in the United States in how I copy things and why I copy things and how I use copied things, or am I sort of an outlier, right? Am I out of the norms of my community, which for the purpose of copyright law would be other university professors like me. So would be more likely to lose a copyright lawsuit if I'm badly photocopying stuff all the time and never getting permission at all, versus other professors who are not copying so much or getting permission more often. Okay. So the other point and I'll take questions or comments here in a few minutes. The other point I wanted to talk about tonight was plagiarism. And plagiarism is a serious issue on university campuses, college and university campuses. Something like 40% of American college students admit to plagiarizing regularly or semi-regularly, at least to a little extent. I recently spent 2 years teaching in China, which some of you know, some of you don't know. And Chinese students are grand masters at plagiarism. If I thought plagiarism was bad with my American students, which I haven't really thought so, but I've not liked what I've seen, well, it certainly was significantly worse among Chinese students. Anyway, so what is plagiarism? Well, I'm not going to belabor this very long here, I find it always kind of strange that there's ever much question about what it is, really. Plagiarism is using other people's words or even their ideas without giving proper credit. It's just that simple. So, excuse me, so where's the gray area? Well, maybe a gray area might be, you think you're paraphrasing someone, you're rewriting what someone else wrote into your own words, but maybe sometimes you only use 25% of your own words and 75% of their the original author's words. Well, that's obviously plagiarism when you're only changing 25% of the words. What if you're changing 75% of the words and only using 25% of the original words? Is that plagiarism? Well, maybe a tougher call. But so I've ended up putting directions into my paper instructions, like, anytime you use more than 8 words in a row from another source, you got to give credit. Got to cite your source. And I put things in there, like, you need to cite your source even for ideas, right? And I tell my students about, when we're, for example, working on a research paper, the ideas of the idea of presenting other people's work in say a literature review or some pro and con argument sections of the paper, and having lots and lots of citations and giving lots of all the necessary proper credit in there, and then leaving their own opinions to the conclusion section of the paper. And so, in which I expect to see no material from any other sources other than their own brains in the conclusion section. So, when in doubt, cite. There are, of course, tips to do this. Keep yourself honest on plagiarism, about taking careful notes, and maybe making little notations to yourself about P for paraphrase and Q for quote, and maybe M for myself or O for original or whatever, where you've got literally notes labeled as to what the source was for each sentence or each paragraph. Students should keep multiple drafts, each separately, instead of continuing to write over earlier drafts of paper. They should each time they work on the paper, they should make a new draft and make a new computer file, so they it doesn't get confused when you're editing what you kept that was other people's words and what you rewrote and so on. And I don't know. I'm not going to say anything more about plagiarism, because I'd be glad to take questions about it. But I always been just perplexed by how so many students and even professors are sometimes a little bit unsure about what it is. To me it's quite simple. It's when you get something from anyone else, to give credit clearly and openly and repeatedly and so on. And plagiarism is particularly concerning because sometimes it's phrased on university campuses as merely, not that this is trivial, as being an honor code violation or a violation of college policy or whatever you want to call it. And it's sort of viewed as merely an ethics issue or a moral lapse and so on. But I hope you've gathered tonight that plagiarism is also a copyright violation. So plagiarism on a college campus is really awful, because it is both unethical and illegal to plagiarize. That's regardless of fair use. So, okay, thank you very much. I'll take questions. Yes.
Is there any way you can use the transformation clause to enable you to use the background music that you assign to a video that you produced yourself? I mean,
yeah, I mean the question on using music in videos is kind of complex, because is the music really crucial or key to the video, or is it kind of just incidental or even accidental that it's in the video? And music is, music is, unfortunately, there's court decisions that now said that any use of someone else's music for any kind of benefit or commercial purpose at all without permission is copyright infringement. This has come up with these with the rap artists who do sampling, right? They borrow 3 seconds from this song and 5 seconds from that song for their own song, and there's actually a circuit court decision that says there's no such thing as too small as a small enough amount that is not copyright infringement when it comes to using other people's music. So this area is kind of hardcore, but there's ways around this: getting permission to use the music, paying a royalty or licensing fee, or transforming the music. So there, or using it just strictly for educational purposes, for example, is safe. So, okay. Anybody else? Yes.
So on a college campus that has a radio station, you're oftentimes hooked up with agencies like BMI and ASCAP that give you licensing to be able to play music, and that oftentimes will cover things on campus for fair use.
Yes.
In terms of like, if you're creating a video.
Sure.
So is there any kind of a conflict that goes on? Do you need to take it further than that? Like, let's say you were making a video to help promote the school. That could be considered commercial, right? So do you think it gets covered by BMI and ASCAP in that?
Certainly marketing a university is not what you would normally call an educational use, right? So, but it depends on the terms of that agreement. What does the agreement say, right? Does the agreement say this only applies to the campus radio station, or does it say it applies to the whole campus?
Yeah,
or
right.
Well, then I'd say just go with it then.
Okay.
Yeah, sure. Okay. Anything else? Anybody else? Okay, well, thanks again for coming tonight. There's still food outside. If you need another snack, please take some. That's why it's here. And next month we will be having 2 more Pedas Center events. The first week of December, I'll be giving another talk on a completely different topic, sort of issues and problems in the so-called dark side of the internet, both in the U.S. and elsewhere around the world. And then the week after that, during finals week, we'll have a fun night it's going to be called something like the best phone apps you've never heard of, something like that. So and Robert Carpenter is spearheading the planning for that evening. So, and then in spring semester we'll have a whole variety of other events and presentations on in a variety of formats and on a variety of topics. So. Please keep watching for announcements on the Teal website and the Record Argus and elsewhere. Anyway, thank you and good night.